The hour of 2:45 having arrived, the Rules Committee shall come to order. The Secretary will take the roll.
Chair Bradford,
Here.
Bizarro, Daly, Davis, Fiedler, Frankel,
Designation.
Harkins, Harris,
Designation.
Kinsey,
Designation.
Kozarowski,
Designation.
Kruger, Speaker McClinton,
Designation.
McNeil, Miller, Parker, Sanchez,
Designation.
Schlossberg, Schusterman. Chair Cutler,
Here.
Delosier, Dunbar, Fee,
Designation.
Fritz,
Designation.
Grove, Kale,
Leave.
Kaufman, Plunk, Lawrence, O'Neill, Oberlander,
Designation.
Pickett,
Designation.
Topper,
Designation.
White.
Thank you. Having established the quorum, the committee is in order to proceed. The chair moves to report D-08858, a resolution originating in the Rules Committee. Is there a second? Representative Schlossberg. This resolution creates the Committee on Rules Subcommittee to deal with incapacity inquiries. Is there any discussion on the resolution? Leader Cutler. Plunk and Cutler. In which order, sir? You are the leader, so let's do Clunk first.
Chivalry is not dead, Mr. Chairman.
Thank you, Mr. Chair. Today, we have a rule change before us, and this is rather unprecedented. This particular rule change would create a subcommittee that shall consist of the Speaker, the Majority Leader, the Majority Caucus Chair, the Minority Leader, and the Minority Caucus Chair. Mr. Chair, in looking at this, this is not a committee that will take a collaborative and bipartisan approach to a situation as concerning as determining whether or not an individual member of this body is incapacitated and cannot carry out their duties. Mr. Chair, I currently serve on the Ethics Committee and have for a number of sessions. Our Ethics Committee has worked in an effective, bipartisan, and collaborative way for over 55 years. Mr. Chair, this particular proposal today flies in the face of the work of that Ethics Committee in a bipartisan and collaborative way to determine whether or not an individual of this body, a duly elected member of this body, is incapacitated and unable to serve. I fully believe that if there is a rule violation, if there is a question of incapacity, there should be a committee set up very similarly to our Ethics Committee, again, that operates in a bipartisan, collaborative way, where we have to work together through an issue, ensuring due process, and not skewing things for one side or the other. We, again, work in a collaborative and bipartisan way. And for that reason, I will be voting no on this. I cannot believe that we have a rule change before us that would skew things in such a manner, especially on a topic as concerning incapacity of a member. I just cannot believe that this is before us today. I'm a proud member of the Ethics Committee, and we work together in a bipartisan and, again, collaborative way, and that is what we should be doing, and working in a collaborative and bipartisan way in coming up with a solution for the problem that is before this body, and that is not happening in this proposal before us. It is not happening with what has happened to get us to this point, Mr. Chair, and I am just absolutely ashamed that we are moving forward like this. Thank you.
Thank you, madam. Next up, I believe, is the good gentleman from York, Representative Grove.
Thank you. Couldn't help but notice we're creating an inquisition committee with no cameras and no transparency. It's unknown who's paying for this, if we're going to hire outside counsel, because without a doubt, this is going to get litigated if we were to inquisition a member of the House of Representatives through this process. So is the head inquisitor going to be general counsel and staff, or is it going to be outside counsel, which will take a lot of time, a lot of expense, and a lot of legal processes to do that? It's the wrong process. Utterly lacks transparency. Not the first time we've had major votes in here without cameras, without disclosure to the public. We are constitutionally elected officers. You know, at the end of the day, voters make their decision. There is a process in place to expel a member. It requires 2/3 vote of this body. You know, we're adding cost and creating a partisan process designed for one individual. I will be a no. Thank you.
Thank you, Chairman. I believe before we get to the leader, last we have, oh, I apologize, lady from Northeast Philly.
Thank you, Mr. Chair. I have grave concerns regarding this piece of legislation and rule change to create an inquisition committee as it pertains to attacking women. I'm very deeply concerned that the subpoena power that is granted under this authority could reach deep into the medical records of all women in this chamber that are brought before this committee. Subpoenaing medical records regarding abortions that women may have had in the past. Subpoenaing records regarding maybe postpartum depression of mothers across our chamber. I find that this committee is an absolute insult and is something that should not be permitted to take place, especially because it would be in the control of just one majority party. You are placing the power of the many into the hands of the very few, and that very few meaning one. I appreciate this committee's time on this matter. Thank you.
Thank you. Next up, the whip from Allegheny County.
Washington County, but that's okay, Mr. Chairman.
In ballpark.
Sure, yeah. You know, I think it's pretty remarkable that we find ourselves here talking about, you know, what you've already heard my colleagues refer to as an inquisition committee. But I do think we need to recognize and dive into a little bit of the details as well. You heard Representative Klunk talk about the members of the committee, the 5 members of the House. But the resolution goes further to actually suggest that the only people that can actually start the process are the 2 leaders, and they can only start it of a member of their own party. Just so think of the authoritarian nature of that move. To have the sole person as the leader, the floor leader of their party, determine whether or not they can start the process of an incapacitation inquest or inquiry. In addition to that, the resolution has no definition whatsoever about what it means to be incapacitated. As a matter of fact, the 5 members of the committee, again, as pointed out by the gentlelady from Philadelphia, a majority vote determines whether or not there is indeed incapacitation once the inquiry begins. So the idea that we are going to create this process that gives so much control and power into very few people within the body and with the chamber is remarkable. In addition to that, let's think about this for a second, that we already have processes in place for this. Prior to COVID, before we had remote voting, it was not uncommon. As a matter of fact, since I've only been here 6 years, and on multiple occasions, there have been members that have been legitimately incapacitated and unable to come to the floor of the House. Guess what? They went on leave. That's it. They went on leave. We had one that I recall when I was first here on the Democrat side of the aisle. Since then, we had at least one on the Republican side of the aisle. The process for incapacitation already exists. Not to mention, there's already a process outlined in the Constitution on how to get rid of a member that shouldn't be here. We can already expel a member if the body deems it so. This is unnecessary, it's authoritarian, and quite frankly, it's predicated on an arrest warrant that was issued in error. Let's not forget why we sit here today and why this proposal was made in the first place. This was a direct response to the mistake and the error of the arrest warrant issued for Kevin Boyle. This is a horrible idea. This is a proposal that goes directly into the face of democracy. And there shouldn't be one member in this House of Representatives that swore an oath to our Constitution that's willing to support this kangaroo court.
Thank you, Mr. Whip. Now for the Minority Leader.
Thank you, Mr. Chairman. Mr. Chairman, I think House Resolution 403, which, for the record, I received in an email at 14:28 earlier this afternoon, so about half an hour ago, not even, is one of the most dangerous resolutions that I've ever seen introduced in this body. And I do not speak lightly or with hyperbole when I say that this creates an involuntary commitment committee. The committee formed in this resolution is a stacked, secret, one-sided panel able to compel members to potentially testify against themselves outside of the public eye, and this committee is able to place arbitrary and I believe unconstitutional penalties on its victims when you dive into the provisions that are contained in this resolution. I recognize that this is a second attempt, I believe, at 403 as it was originally introduced. But I'd like to run through some of the issues that still remain in this current version. The first one is the obvious conflicts with health law and the ADA, because the ADA specifically limits examinations and the use to job-related functions. So I think there's legitimate legal questions regarding how this resolution would be applied in those cases. It's essentially a requirement that as a condition of holding public office, you may be required to totally and completely give up your privacy rights and potentially have your health care and financial records subpoenaed. I'll ask this question rhetorically. What private, medical, or personal information does each member here want to put before a secret committee to be judged in secret? We've already discussed the makeup of the committee. It's 3-2. It's partisan. I do not believe, and it's the same reason I argued against the current rules that I did not vote for because of the partisan nature of how they're drawn up. If we want to have a model on how to approach this problem, I would simply offer that the Ethics Committee, the 4-4 status, already exists. It's already there. So what other treatments and issues will be potentially disclosed in this secret tribunal? In addition, the punishments that are provided in here include suspension with or without pay and are seriously at odds with already provided for punishments in our existing Constitution. We don't have to reinvent the wheel. A solution to this already exists. I have concerns about the transparency and the secrecy that this committee will ultimately result in. It will examine members in secret. It will issue judgments in secret by a majority vote of a partisan committee that is made up 3-2. And a minority view, as near as I can tell in the quick 30 minutes that I've had to review this, there is no provision for a minority report or other mitigating factors that might have been considered. I question significantly if this deprives members on both sides of the aisle of their due process rights. A fair hearing, and whether the public, who quite frankly elected us as the members to the positions that we now hold, have had sufficient input. We're going to allow, and I want to echo the good gentleman from Washington County's concerns, we're going to allow the floor leader of each party to hold this over their members going forward. I have major concerns about that. I've spent my entire career here decentralizing power and giving power to individual members and committee chairs to consider issues. I recognize that as leaders, we have unique situations that we have to confront. I would simply offer that we have. When you look at the past history of how these were handled previously, they typically were handled by putting members on leave. I'd also question what our friends in the press think about being excluded from this entire process, because there's no provisions for public access. In fact, it goes a step further and says in secret. I'm concerned about the makeup of the committee, and I think that one of the things that I've learned here in the rules that were passed previously, which were very partisan, both in terms of their makeup and their ultimate vote when they were adopted, is that when the House Democrats stack the deck, they're only seeking to impose their will and not engage in a fair and open process. And I would simply offer this as the next exhibit. I mentioned before the Ethics Committee because I think that we should use an existing structure in the House for that conduct review if we believe it is warranted. I think it sounds a little bit better than a secret committee. But most importantly, we could use common sense and the opportunities that we already have contained both in our rules by simply putting somebody on leave, or conversely, doing an expulsion hearing. Those are the two remedies that already exist. We don't have to create a secret tribunal to do something different. That's why I'm a no. I do not support this. I did not vote for the rules. They're partisan in nature, and I will not continue to support anything that looks like this. Our version of the rules last session significantly limited the ability to remote vote to very serious situations. That was removed. That opportunity was broadened. Under this current version, I disagreed. I voiced my objection by being a no. I will once again voice my opposition to what I think is a very bad idea of the current proposal that we have. If the conduct of a member rises to the level of being put before a secret tribunal, maybe it should also rise to the level of being expelled. A resolution can be put together. We did it both for a judge and a county commissioner previously in prior sessions. We also impeached. I recognize this is a different process, but the fundamental processes for developing the resolution remain the same. It can be fully debated in public, in committee, on the House floor, and our Constitution and due process requirements would all be abided by. Again, simple problems do not need complicated solutions. And for the members of the press, I would simply ask, how many votes this week were at 102? I think we know the real reason that somebody's not been put on leave or expelled. I'll be no. I believe this is ripe for a challenge in the courts and is unconstitutional.
Thank you, Mr. Leader. And I also want to thank you, as we've communicated for the past several months, dealing with a very delicate personnel issue, which I know involves an individual who we keep in our prayers and thoughts constantly and realize the gravity of the situation. But what we have in front of us is not about any one individual. It's not about any one fact pattern. It's about a very real challenge. It is as a result, in no small part, as a result of a designation that was put in a prior session that continues to stay in place until removed. And the simple reality is that we are dealing with an unparalleled and historic first challenge, but one that this majority will deal with. I've served in the minority previously, and I know it is great to go on with such rhetoric, and I appreciate what I heard, that we should have no process and move to an immediate expulsion. We should have some process through the Ethics Committee. Listen, that's all great. I've sat there with armed guards on the floor when nothing was done. This majority has been very clear. We will move expeditiously. We will move compassionately. We will not have a replay of what we saw on the floor several weeks ago with the political theater and the nonsense, where we slandered people without any due process or knowledge of the facts or the circumstances. So what we are going to do is do right by this chamber. We're going to be compassionate. We're going to be thoughtful. This is an amendment today. It is not the final word. I have spoken to you since April 19th when this was originally posted. This was not just moments ago. Any claim to the contrary is false. There is an amendment. Leader, please, I let you speak uninterrupted for quite a bit of time and dealt with some facts that I didn't fully agree with, but I am going to let you do that. We're going to quickly come to a vote because I don't believe that this needs to be the spectacle that others would like it to be. What this needs to be is this legislature doing the best by everyone in a confidential process that is exactly what the ethics process would be. This is a nonpartisan process. In fact, it is so nonpartisan, it can only be initiated by a member of one's own leadership. Now, having said that, listen, this is not the final word, but when I tell you that this majority will move expeditiously, compassionately, without theater, to make sure that we deal with challenges, as historic and unparalleled as they may be, we will do that. Unperfect facts create unperfect processes. We will work to improve the process in front of us. We recognize perfection is not in front of us, but there is a shared humanity that we see across partisan lines, and we need to recognize the gravity and the seriousness of the situation and check the politics for 1 minute. It overtook some on the floor a few weeks ago when they made grandiose, outlandish, false, and defamatory in some case comments. It was beneath the dignity of this building. Now, we are going to, no, I let you speak, and we're going to move to a vote, Leader. We're going to very quickly move to a vote on this, and we are going to work among our members and among advocates and experts in this and other states to deal with the historic and unparalleled position we find ourselves in. Now, with that, seeing no further discussion, all those in favor reporting the resolution will vote aye. Those opposed, no. The Secretary will call the roll. I will note that all Democrats shall be marked in the affirmative. The Republicans, Mr. Leader? Would you like a roll
You
call
asked
for the
a call into
Republicans?
the roll, Mr. Chairman.
Oh, I apologize. The
I wasn't
Republicans-
sure if this was a proper time to speak since you failed to recognize me when I sought recognition previously regarding
Mr.
your
Leader,
inaccuracies.
Mr. Leader, please. We have already listened to you ad nauseum about this. Let's move to a
Actually,
vote.
you haven't, Mr. Leader. You haven't. I sought recognition and you denied me the opportunity to speak.
Sir, I
Is this how the panel's going to be run? Because it's inappropriate.
Only the vote's in order. I will again, please ask that the Republican roll be called.
Chair Cutler, Delosier, Dunbar, Fee,
No.
Fritz,
Designation no.
Grove, Hale,
Leave.
Kaufman, Plunk, Lawrence, O'Neill, Oberlander,
Designation no.
Pickett,
Designation no.
Topper,
Designation no.
White.
The ayes are 18, the nays are 14, the resolution passes. Seeing no further business before the committee, I move that the Rules Committee meeting be adjourned. Those in favor say aye, those opposed no. The ayes have it, the Rules Committee meeting is adjourned.